fact of the matter in this case is when you have a company that's been careless and a negligent driver, well then people are going to get seriously injured.
Let me tell you what I see. So what I see is someone who is very comfortable in a courtroom. How did you get to be comfortable in a courtroom?
Probably goes back to law school. I had a great mock trial teacher, Judge David Mason, and he would hammer into us every weekend about courtroom presence and making sure that you have great courtroom presence, and was really critical of everything we did in a mock trial courtroom. And so frankly, it really started 8 years ago in law school with Judge Mason, and just kind of grew from there as I began to try more cases.
Here's what I want to see.
Mm-hmm.
I haven't even been told, and I mean, different courtrooms have different rules, but what's the case worth?
Mm-hmm.
And I see that you followed, was this Rules of the Road?
Mm-hmm. Yep.
Rick Friedman, who's a friend and mentor of mine, the way you laid out the rules is perfect, absolutely perfect. The one thing I add in is right off the bat, tell the jurors what the case is worth.
Okay.
And I started doing this. Courtney's here. She's jumping on in.
Hey, Courtney.
Good to see you.
See you too.
What we started doing really within the past, maybe 3-4 years,
Mm-hmm.
is we put the dollar amount up right away.
Mm.
First slide. This is what the case. This is what this is worth for changing a human being's life. This much for Are you allowed to do per diems in Georgia?
You can, yes.
Per diem argument, and I don't necessarily do a calculation there, but I do is she was, how old was she?
She was 29 at the time of the
29. Okay. So say 50 years of life, 50 years of injury, this many months, boom, boom, and you put a range in there. That's reasonable. Let me tell you why. Boom. And then go. So that's the one thing I would throw in right from the very beginning, because this is a damages case. Right? So hit damages up right away. That's what I want people to learn from this, because I don't think I've had an opportunity to teach that much. But hit right away. If liability is really in dispute, and that's going to be something tough you have to fight on, maybe even consider doing a motion to bifurcate. Say, all right, we'll try the case on liability first if you can. If liability is being disputed and you're not bifurcating, then tell the jurors this is what it's worth. But we don't even get there until we prove that the defense is at fault. So the first thing we have to do in this case is prove that. And that's our burden of proof, because they won't accept responsibility for it. So we're going to take some of your time to establish that they're at fault. And we thank you for that time, but we got to get across that bridge first before I justify and show you why this is worth that much money.
Yeah, to be clear, when we pop it up, it's just the number going up on the board. And a lot of times I don't even
We're not going
say
into
the
the
number.
human story.
I don't even say the number. Sometimes it's just, I pop it up.
It's there. That's what it's worth.
That's what it's worth. Let me get into it. It's a little aggressive.
Yep. That'll be a reasonable jury verdict based upon the law and the evidence that the judge is going to give you, and the evidence that you're going to see.
And then
boom,
straight into what you did.